Lawyers told the leader of the proscribed indigenous people of Biafra, Nnamdi Kanu, says his case has turned from the legal or judicial one to a political case. Addressing journalists in Abuja, the lawyers say,
in any Nigerian university, and indeed any other person, the sum of 1 million naira, if such student finds any precedent on stay of execution in criminal proceeding where an acquitted person is by such order restrained from enjoying his freedom. It is an illegality that would haunt Nigeria for a long time to come. But then, it was granted because Mazi Nnamdi Kanu is of the Igbo extraction and must suffer, notwithstanding what the provisions of the laws are. On the part of the Supreme Court, Onyendu Mazi Nnamdi Kanu did not jump bail, but rather ran away from the treacherous acts of Operation Python Dance to save his life and physical well-being. At page 10 and 11 of the Supreme Court findings and decisions, it was held that the respondent was on bail and therefore in the custody of the law when his home was invaded by heavily armed military officers of the appellant, causing him to flee from his home and country to secure his life. In the face of such an attack, it was reasonable for him to flee to secure his life and physical well-being. That is what any normal and reasonable human being would do in that circumstance to preserve his life and physical well-being. The High Court in Enugu State, in suit number E20/2023, between Mazi Nnamdi Kanu versus Federal Republic of Nigeria and 4 others, delivered on the 26th day of October 2023 by Justice A.O. Onovo, in the enrolled order of its judgment declared thus, that the practical application of the Terrorism Prevention Act and the executive or administrative action of the respondents, which directly led to the proscription of IPOB and its listing as a terrorist group, said IPOB being comprised of citizens of Nigeria of Igbo and Eastern Nigeria ethnic group, professing the political opinion of self-determination and the consequential arrest, detention, and prosecution of applicant as member/leader of the said IPOB is illegal, unlawful, unconstitutional, and amount to infringement of the applicant's fundamental right not to be subjected to any disability or restriction on the basis of his ethnicity as enshrined and guaranteed under Section 42 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, and his fundamental rights as enshrined under Article 2, 3, 19, and 20 of the African Charter on Human and People's Rights Act. Both the decision of the Supreme Court on the unlawfulness of the revocation of Onyendu's bail and the judgment of the High Court of Enugu State remains valid, subsisting, and not tinkered with. But no person obeys them because it does not favor the federal government of Nigeria. In fact, Section 2871 of this and 3 of the Constitution that makes it compulsory for all persons and authority to obey and give effect to the judgment of the Supreme Court. And the trial court is never entrenched in the Constitution as to benefit Mazi Nnamdi Kanu. It is not disputable that Mazi Nnamdi Kanu has the constitutional right to agitate for Biafra. Self-determination is recognized and sanctioned under our laws and under normal circumstances. His prosecutions are the violators of the law of the land. If one may ask, on what premise, therefore, is Mazi Nnamdi Kanu detained in the Department of State Security Service? Are Nigerian court's orders and judgment useless, or useless only as they affect Mazi Nnamdi Kanu? Why is it that when the judgment is against the federal government of Nigeria, they will not be obeyed? In their favor, they quickly rush to obey it. Thank you. At this point, I will hand over to my friend, Honorable Barrister Jude Ugwai.